Good evening, everyone. I'm Saquib Rahman, Senior Lecturer at the Department of Law, North South University, would like to welcome you all to our webinar today. It would be a delight for us to be able to listen to Professor Thomas Streinz, who has very kindly made the time to talk on paradigm shifting international economic law. But before we request Professor Thomas to start, I would like to bring to the notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off at all times. And lastly, I would extend my thanks on behalf of the Department of Law to all of you present here today. Now, regarding our guest speaker, Thomas Trines is the inaugural Executive Director of Guarini Global Law and Tech and an Adjunct Professor of Law at New York University School of Law. He teaches global data and tech law, and together with Professors Benedict Kingsbury and Joseph Weller, convenes the Guarini Colloquium, regulating global digital operations. Prior to joining Guarini Global Law and Tech, he was an Institute Fellow at NYU Law's Institute for International Law and Justice, where he worked on the mega-reg and infra-reg projects. He received his LLM from NYU Law as a Hauser Global Scholar. Prior to coming to New York, he graduated from the Ludwig Maximilian University of Munich and gained professional work experience at international law firm in Munich, the legal service of the European Commission in Brussels, and the German Embassy in Washington, D.C. Now, before we listen to Professor Thomas, I'd like to request Professor Dr. Rizwanul, Chair of the Department of Law at North South University, for his introductory remarks. Please.
Thank you very much, Saquib. Thank you, Professor Streinz, for very generously responding to our request. And thank you to the audience for wherever you may be. Good afternoon or good evening, depending on your location. I think there are many ways of looking at contemporary international law, but I guess for this evening's talk, international law could be viewed through two different lenses. One, through a particularly Westphalian model, which perceives sovereign states as the core of international law, in terms of international lawmaking, in terms of international legal responsibility, and in so many other ways. And not just general public international law, but also in international economic law, I guess there are multiple ways of looking at it. But for this evening's talk, I think there is some intellectual debate and also various questions posed by not just scholars, but also activists working on international law, that how do we perceive international law or international economic law? Is it just a law of the nations, for the nations, or is it something about global governance? Or more particularly for today's talk, is it about global economic governance, which involves not just the states, but also various other non-state actors? Even a body such as the World Trade Organization, although the treaty is made by the states, the treaty regulates the conduct of non-state actors. Much of today's international trade actually, I think, takes place between and among firms. States are not primary actors, except for some state-planned economies. And even in a regime like international investment, where individual investors may have direct rights to sue the host states in a forum like ICSID or ad hoc arbitral bodies. Not everything is being done by the private actors or public actors. There is a plethora of investment agreements which are creating rights, but those rights are often being enforced by private businesses. So I look forward to listening to Professor Streinz, that how he actually views these things and what is his prediction about the future dynamics of international economic law and this, if I may put it this way, the intellectual tension between this international governance and global governance, and what it means for various businesses and us, the individuals. So with that note, thank you all for joining. I look forward to the talk and also to your questions.
Thank you very much, sir. I am sure everybody else is looking forward to the talk of Professor Thomas as well. Professor Thomas, whenever you're ready. Thank you.
Great. Thank you so much for this invitation and for organizing this magnificent series of talks. I feel very honored to be in the list, or I will be in the list on YouTube with luminaries and scholars that I very much admire, and I had a chance to look at some of the previous sessions with Fleur Johns and James Gatti in particular, that really showed what you're putting together here is at the forefront of international legal scholarship. And I'll do my very best to live up to the expectations that my predecessors might have raised with this talk on shifting paradigms in international economic law. And I very much look forward to the discussion after my talk. So I'll try to be relatively brief and encourage all of you to challenge the positions that I will take and the theoretical frames that I will develop in my presentation. This presentation is a bit of a selection of themes and topics that I've been thinking about and working on over the last couple of years. So to some extent, it covers terrain that has already been published through the Megarec project, but to some extent, it's also toying with new ideas. And this phrase, shifting paradigms in international economic law, is how my former colleague, Paul Mertenskötter, and I have tried to think about the ways in which our engagement in the Megarec project has changed our perspectives on international economic law. And the idea is to pull together how shifting paradigms can help us understand how international economic law operates today and how it might, how it could be improved in future. Now, I want to start this talk by acknowledging that I'm standing on the shoulders of giants, and that basically everything I'll talk about today will be influenced in one way or another by the work that I've been doing over the years in the Megarec project at NYU School of Law, where we had a large-scale research initiative to understand global economic governance and the regulatory aspects of it, particularly in the context of the Trans-Pacific Partnership Agreement. And with many others, we put together this volume, Mega Regulation Contested, that is a real doorstopper. But the framing paper and the introduction are also on SSIN, so you don't need to get the whole book to get a sense of what we've been trying to convey in this project. The core of the project was located at NYU Law, where I worked with Benedict Kingsbury, Richard Stewart, and Paul Mertenskötter. And together we studied TPP, and Paul and I read it actually multiple times, which I only recommend if you want to fall asleep. And we tried to understand what this agreement was about, what might be new about it, and whether it might signal a certain shift in the way in which the global economy is being governed. So what you see here on this beautiful map that is adapted from a Japanese designer that tried to get a sense of the vastness of the Pacific is the initial composition of the Trans-Pacific Partnership Agreement, the TPP 12, with all 12 participating countries. As most of you will know, the United States withdrew from the Trans-Pacific Partnership during the first week in which former President Trump was in office, after TPP had become very contentious in the 2016 presidential election and the contest between Hillary Clinton and Donald Trump. But to many surprise, including us, the agreement was being revived and resurrected as the comprehensive and progressive agreement for Trans-Pacific Partnership without the United States, as you can see on this slide. So, and in the process of resurrecting that agreement, the parties retained most of the provisions, but suspended some. And I'll come back to that point later on in my talk. Now, it's important to realize when studying new international agreements in international economic law, whether they are trade agreements or investment agreements, that the agreements like TPP build on a baseline that is being constructed through other agreements, regional free trade agreements, bilateral free trade agreements, and other trade preferences that countries have established between each other. So what you see on this slide is what was already there before TPP came in force. And what you see on this slide is what TPP 11 adds, in fact. So the black connections between the TPP 11 without the United States show you new types of international arrangements between countries that were not there before. Now, many would analyze the TPP as a trade and investment agreement and a comprehensive one at that. But in our appreciation of the agreement, we felt that this traditional trade and investment framing might not capture the substance of the Trans-Pacific Partnership Agreement very well. And we came up with this maybe slightly exaggerated term, mega regulation. And I want to start with this mega regulation concept to then build on the mega regulation concept to contrast what I perceive to be a standard paradigm of international economic law with what one could perceive as a new paradigm of international economic law. And on that basis, I'll show you in 2 case studies what one gets out of adopting the new paradigm, what the standard paradigm might conceal. So mega regulation in TPP, first of all, just connotes that there's a very broad coverage beyond the WTO and also beyond the free trade agreements that came after the WTO was established in 1995. And the focus is not necessarily on trade, but in some instances, in particular with regard to data, it's really about flows. And I'll come back to this idea, what we mean by trade and how trade might be different from flows in a second, but that's a key feature here. The agreement aspires to create an economic area in which the various factors of economic production can flow relatively freely. Secondly, the agreement tries to create a generalized freedom to operate for corporations. And this is one aspect in which we're shifting the paradigm that Professor Islam also alluded to in the beginning, in taking seriously the role that corporations play in international economic law. Countries don't trade, corporations trade. And that's a well-known fact in trade theory among economists and also among trade lawyers, but it's not always reflected in the ways in which we understand international economic law and how we theorize it. And I'll show you later how provisions in TPP can be mobilized and leveraged by globally operating corporations to expand their freedom to operate. It turns out even in cases in which their home country is actually not or no longer party to the agreement. Thirdly, the agreement to enable these flows and to create this generalized freedom to operate for corporations attempts to solve the problem of regulatory divergence by creating regulatory convergence through a process that we call regulatory alignment. And there again is a difference in TPP compared to earlier trade agreements, which often try to either harmonize rules or create enabling environments for the harmonization of rules through mutual recognition commitments, whereas TPP shifts the focus much more to regulatory procedures in domestic lawmaking. So TPP is full of provisions that commit states to reform their regulatory systems in a way that makes those regulatory systems more transparent, more participatory, including for foreign corporations, and enable those foreign corporations to challenge decisions that the domestic regulatory state makes. And I'll come back to that in the second part of my talk when I'll talk about the phenomenon of remote control. Fourthly, agreements like TPP and also the agreement that came after it and was signed last fall, the Regional Comprehensive Economic Partnership, are very large in scale. Some call that mega regional. And one important aspect that we want to highlight here that again differs a little bit from the standard paradigm under which it hugely matters whether a country is party to the agreement or not, is to point out that agreements of that larger scale also have an impact on countries that are actually not party to the agreement. So we call that third-party effects. That might be that countries gravitate towards the agreement, as the United Kingdom, for example, has voiced interest in joining TPP, and a range of other countries around the Pacific Rim are considering that possibility as well. But there are also other types of spillovers, not just the traditional trade diversions, but also in terms of shaping a regulatory agenda, shaping a certain way of doing business in a large-scale economic area and beyond. And fifthly, we thought it was interesting that TPP uses the treaty institutional form. And this, again, is an element where it very much depends on what kind of baseline one adopts, whether one is an international, public international law scholar or practitioner for whom it might be natural that questions of global economic governance are being regulated in a treaty. But if you come from the space of internet governance, for example, the idea that a treaty would be the most natural form to settle how domain names are being allocated would be ludicrous, because that's something that's been allocated to the Internet Corporation for Assigned Names and Numbers, or ICANN. So it's important to point out that here we have states coming together, investing a lot of political capital and legal sophistication to create a treaty and treaty institutions to administer a very complex and very long agreement. And that realization is relevant if you want to compare TPP as a form of economic ordering with other forms of economic ordering, like the Belt and Road Initiative, that I'll talk about a little bit towards the end. So we thought these 5 elements are what makes TPP distinctive and what we can together describe as mega regulation. Okay. So this is what we came up with in the MegaReg project. And my colleague, Paul Metzger and I realized in talking to other colleagues at conferences and in practice that having teased out these features of TPP and coming up with this concept of mega regulation had changed our views about international economic law completely. Now, if in announcing this talk as being a talk about international economic law, one faces the difficulty that international economic law is not a very well-defined term, and it's being taught across the world in different institutions in different ways. One can have a relatively narrow view where it's mainly about the international public law of trade and the international law of investment, but one can also have a much more expansive view, including international finance and other forms of regulatory coordination between countries and beyond to encompass international economic law. So in this talk, I'll mainly talk about international trade law, but the paradigm shifts that I will identify are also relevant for other areas of international economic law. Now, the standard paradigm, as we perceive it, is very much associated with the related shift in perspective that Professor Islam was talking about in his introduction. Whether we conceive of the world through the lens of the Westphalian model, where the nation state is the focal point of our inquiry and the key to understand its legal commitments and responsibilities under international law, or whether we cast the web much more broadly and consider other actors that are also relevant for the operation and implementation of international economic law, even though traditional international law would not consider them subjects of international law. So that's how the standard paradigm relates very much to this traditional view of international law. But what's important in the context of international economic law is that not only is the state a construct that we can question and second guess, the economy is a construct as well. And international economic law, how it's mostly taught and understood and practiced, has this idea that there's the nation state that is congruent with its national economy, in which national consumers, national firms, and other national firms engage in commercial activity among each other. So firms compete with each other, consumers buy goods and services from these national firms. All that together is the national economy, and it's congruent with the nation state. It's important to realize that this is not the only way in which we can see the world. There are other ways of conceiving of the economy and its relationship with the state. And it's an interesting history how that construct of the national economy came about. Now, in international economic law, this paradigm is being extended to the transnational. So instead of just looking at one state and how it relates to its economy, we have two states and their respective national economies, national firms, national consumers. And on the legal side, they might have an international trade agreement between each other, creating more preferential terms than the World Trade Organization might provide. But in addition, they exchange imports and exports across the border. So that's the standard paradigm of trade. The problem with that standard paradigm of trade is that it doesn't reflect economic reality, and it's also out of sync with what trade agreements actually regulate, because increasingly they are not regulating the import and export of goods and services, but they're regulating questions of global economic governance much, much more broadly. And that's what we're trying to capture with this new paradigm. And as I alluded to earlier, this new paradigm departs from what Professor Kingsbury always calls the foreign office model, where when we think about international law, we are focused on the foreign office, we are focused on diplomacy and the kinds of international commitments that nation states negotiate among each other through the foreign office. In a global governance model, we take a much broader view, and we are interested in the various kinds of connections that exist in the global economy. And in comparison to the standard paradigm, that brings into view actors like standard setting organizations. They are hugely important for the operation of the global economy. It brings into view non-governmental organizations, the activists that might push against trade agreements, as well as the industry associations that might push for them. It brings into view corporations in particular, because as Professor Islam very rightly said at the very beginning, a lot of trade is actually not from one firm to the other, as the standard paradigm would suggest it, but it is within the firm. The firm is trading with itself in constructs that are known as global value chains that are mostly constructed through contract law, but also depend on international economic law to create the foundational conditions under which firms can trade with each other under favorable term. And as the current Suez Canal crisis has shown, there are other elements, including infrastructure, that are relevant for the operation of international economic law and for it to achieve the objectives that it seeks to achieve. So this global governance model is still looking at treaties and custom as the traditional sources of international law, but it puts these sources of international law in context with the activities of a whole range of actors. And that's what I want to show you now in the second part of my presentation with two case studies, one on remote control and one on the regulation of data flows in international economic law. Now, remote control is a term that my former colleague Paul Metzger and Richard Stewart coined to describe the phenomenon under which globally operating corporations can use the changes that treaty commitments and agreements like TPP bring about to influence the regulatory policies of other states. And they do that by building on a theoretical model that is quite well known in the United States. It's developed by three authors that together go as McNolgast, who sought to answer the question how regulatory agencies could be held in check. So what you see on the slide is that a political principle, for example, a legislature, decides to provide statutory delegation to a regulatory agency, for example, an environmental agency. And the problem now is how to make sure that this agency does its job, how to ensure that it doesn't stray from its mission. And that's often being analyzed as a principal-agent problem, where the principal, Congress, might have a problem with its agent, the regulatory agency. And the theory that McNolgast came up with is that the economic and social interests that might otherwise need to pressure Congress so that Congress could exercise influence over the regulatory agency could exercise influence directly on the agency if that agency has procedures in place that allow these economic and social interests to be heard. And that's where core requirements in US administrative law about transparency, reason giving, and review are coming from. And the most notable aspect of this is known as notice and comment rulemaking, where the agency proposes a certain rule, and then corporate actors in particular can lobby the agency to make changes to that rule through a process of notice and comment. Now, what does this have to do with international economic law? Well, the reality is that we now have a similar phenomenon occurring on a transnational scale enabled by international economic law. So in this slide, what you see is that we have two states now, nation state A and nation state B, and the governments of those states, the political actors, negotiated in between them a trade agreement, like TPP, for example. But what this trade agreement does is that it reforms the regulatory state in state B, assuming that state A, for example, already has notice and comment rulemaking. So it's easy to imagine here the United States being state A and a TPP member state like Vietnam being state B. Under TPP, especially in its initial version, as the remaining 11 parties were smart enough to suspend some of the provisions that would have favored US corporations most, TPP required its participating countries to change its regulatory systems in ways that would allow foreign actors, often called interested persons, to see what is going on, to see what kind of rulemaking the regulatory actor in state B is engaged in, and to influence that rulemaking through notice and comment type procedures, through review mechanisms, with the goal being to create a more uniform area. You see here how this is actually a very smart way of achieving regulatory convergence. Instead of using the treaty and trying to come up in the treaty with commitments that are acceptable to all parties, the treaty shifts focus towards procedural requirements in the agreement that then open up the regulatory systems of the various states that are parties to the agreement, so that economic and social interests can impact the domestic rulemaking. And that, of course, changes the political economy in countries that participate in these kinds of agreements quite radically, because it's no longer just the domestic actors that can influence the rulemaking, either through legal means or through illegal means. Now it's also the international and globally operating corporations. So this is one way in which these new types of agreements change what international economic law is all about. And the paradigm shift from the nation state focus to other actors is relevant, because otherwise this picture wouldn't come fully into view. If you only looked at the entities that are bound by the agreement, you would only see state A and state B, because that's what's relevant under international law. But the reality is that we often need to look inside the state and to consider all the actors that might benefit from international economic law, or that might leverage international economic law to their advantage, to assess whether international economic law is achieving what we wanted to achieve. So that was my first example, remote control. And my second example is about the area that I'm mostly focused on these days, which is trade, digital trade and data governance in international economic law. And you already heard a very critical perspective on this whole agenda by Jane Kelsey. What I want to show you in the next 5 or 10 minutes or so is how this key fact that the United States withdrew from TPP may not be as relevant as is commonly believed, because US corporations can still benefit from the commitments that the US initially negotiated and that the remaining 11 parties kept in the resurrected Comprehensive and Progressive Agreement for Trans-Pacific Partnership. That's especially relevant with regard to the digital economy, because TPP created a new model that has since been replicated in other agreements. So what you see on the slide is how the CPTPP countries for which the agreement is in force, which is only 7, Australia, New Zealand, Canada, Vietnam, Singapore, Japan, and Mexico, are bound by the commitments they entered into under CPTPP, and they have partly tried to extend those commitments or to reinforce them. So New Zealand and Singapore, together with Chile, created DEPA or DEPA, the Digital Economy Partnership Agreements. And the United States, even though it withdrew from TPP, took the TPP template for the digital economy and put it into the new NAFTA agreement between Canada, Mexico, and the United States, and into the digital trade agreement between the United States and Japan. And Chile, as I alluded to, has been a part of all these efforts, but didn't manage to ratify the agreements for political purposes. If you look at a slide like this or a slide like that, you get the impression that what matters is whether a country is a party to the agreement. And that's also what would matter under a Westphalian perspective or under what we describe as the standard paradigm, because the relevant frame of reference is the nation state. But it misses what these agreements actually do. So looking at just one provision in TPP, Article 1411, which is about the cross-border transfer of information by electronic means, so cross-border data flows. And this provision that is part of the e-commerce chapter in TPP applies, it says, when the data flow is for the conduct of the business of a covered person. And that question, what is a covered person, sends you down a very complicated line of definitions that I'll just quickly jump through. Because what's happening here is that international trade law and investment law suddenly intersect. So covered person is mainly defined with regard to investment categories. So you either have to be a covered investment or an investor of a party or a service supplier. And I'll leave the services to the side for a moment, which are also interesting in between how trade in goods is being regulated under international economic law and how investment is being regulated in international economic law, to just focus on the investment definitions here. Because the key point is that the investor and investment categories are malleable. Corporations can become investors. It's not a state of nature. You can have lawyers that make you an investor of a party. Because the key point here is that to become an investor of a party, you either need to be a national, but you can also be an enterprise of a party. And the enterprise of a party is described in a very, very broad way, which is borrowed from international investment law, for which it's enough that you are constituted and organized under the law of another party, or that you just have a branch there that's doing business activity there. That's enough to be an enterprise of a party. Now, what does that mean in practice? It means that the complication of corporate nationality, that corporations, globally operating corporations, have multiple nationalities in place, complicates our analysis under international economic law if we don't shift from the standard paradigm to a paradigm that accounts for corporate multinationality in our analysis. This slide is taken from a very good report by UNCTAD and the World Investment Report 2016 that analyzed the causes of different forms and configurations of corporate ownership. And you see on the right-hand side how we can have different configurations with a foreign direct owner, a foreign ultimate owner from different countries. And this 2A constellation is the one I want to focus on because it strikes me as the most relevant with regard to the digital trade provision that I showed you. If you read Article 1411 TPP through the standard paradigm, you might think that it regulates that if there's a company in Vietnam that wants to transfer data to its company headquarters in Singapore, Vietnam needs to allow that unless there are exceptions in place that would justify the restrictions. And I'm happy to talk more about this complicated question under which conditions countries should be allowed under international economic law to restrict cross-border data flows. So this would be the standard paradigm. CPTPP is enforced for Singapore and Vietnam, and it allows cross-border data transfers between those countries, while in reality, the data transfer is between companies in those countries. The US is not part of that picture. It's no longer party to TPP. A US corporation is not going to benefit from the data flow provisions that might apply between Singapore and Vietnam. That's the price you pay if you're no longer party to an agreement. But the reality is different. The reality is that the US corporation might control the Singaporean corporation, which might control the Vietnamese corporation. In that scenario, the US corporation is an investor of a party, an investor of Singapore, that has done an investment in Vietnam. And that means that the US corporation benefits indirectly from the provision that guarantees the data flow between Vietnam and Singapore. And if you read closely, it also guarantees the data flow to the United States, because there's nothing in Article 1411 TPP that suggests that the countries that are bound by these kinds of commitments need only allow data flows between the countries that are party to the agreements. It's a global obligation. It's a kind of erga omnes obligation. They need to allow data flows vis-a-vis all countries, including the home states of corporations that might no longer be parties to the agreement. And this, again, is an example how paradigm shifting in this way, taking seriously the role of globally operating corporations in international economic law, can reveal what provisions like Article 1411 TPP actually mean. You might say, well, Article 1411 TPP is part of an agreement between 11 countries in force between 7. What happens if a country refuses to comply, which raises the age-old question of enforcement in international law? And what I would say there is that one shouldn't overestimate the importance of formal dispute settlement, the importance of formal enforcement procedures, in particular the formal state-to-state dispute settlement that is commonly deployed in international trade law, and that also applies to a provision like Article 1411 TPP, where the Foreign Office model applies at the surface. So one government would need to take action against another government, and corporations play a role by lobbying their governments to take actions against another government. So even there, it makes sense to consider seriously how corporations might be behind the various state-to-state dispute settlement procedures that are being launched. And they're also the ones that are being hurt if tariffs are being deployed in retaliation. But it's also important to consider the ways in which international economic law has an impact beyond formal dispute settlement proceedings. And I'm drawing here again on a paper by my former colleague Paul Mertenskötter with Tim Dorlach, who was published in Law and Society Review, where they studied Chile's efforts to create a new food label for chocolate bars, which was opposed by the global food industry, that often invoked international economic law to make claims to the fact that this kind of food labeling would be in violation of the agreement on technical barriers to trade, the TBT agreement. And these lawyers would make these arguments vis-a-vis trade officials, but also vis-a-vis the bureaucrats responsible with creating this kind of health-related regulation in Chile and in countries around the world. So this is another way in which international economic law operates that we don't see if we only focus on the WTO dispute settlement. So with that example of how CPTPP is still relevant for the United States, I want to close by just drawing your attention to the Regional Comprehensive Economic Partnership Agreement that was signed last fall, that in many ways resembles TPP in its structure and ambition. And even though most observers see it as a less ambitious agreement than TPP, I wouldn't underestimate the extent to which it creates a new template for East and Southeast Asia in particular, that raises intricate questions for the neighboring countries that are not party to that agreement. And I also want to draw attention, of course, to the Belt and Road Initiative, which in some ways goes the other way. Whereas agreements like TPP create a treaty infrastructure for global economic commerce that is being filled out by corporations trading with each other and with themselves, and assuming that the infrastructure for that is in place, the Belt and Road Initiative goes the other way by creating infrastructure, by financing infrastructure development, most of which is related to logistics, to create the material conditions for global trade without creating the treaty infrastructure. And it's going to be interesting to see whether we'll see some kind of treaty infrastructure emerging down the line, at least on some of the issues that routinely come up in complex trade governance. With that, I will end here. I thank you a lot for the invitation and for the attention. I very much look forward to the discussion. Thanks a lot.
Thank you very much, Professor Thomas. Professor Thomas, we do have certain questions, and whenever you're ready, I will start asking you the questions, and you may entertain them.
Sure.
All right. Professor Thomas, this is your first question. Could you please explain who the more enthusiastic, Professor Thomas, I should read the first question at first. Question number one, would it be fair to say that the transnational corporations have and would continue to have a more significant say than what they have in the WTO in formulating mega regulations?
Yeah, thanks a lot for the question. I think that there are several components to that. And let me maybe just briefly highlight three aspects. One is the comparison between large multinational corporations and small and medium-sized enterprises. If you look at, if you attend trade conferences, if you listen to those who advocate for more ambitious preferential trade agreements, they will often say that these agreements are necessary for small and medium-sized enterprises. And after studying TPP, we have some doubts about that. And in our book, there's a chapter by Dan Syriac, who is a trade economist from Canada, who is looking at these provisions and is asking himself, who are the most likely entities that might benefit from them? And he finds that it's often larger corporations, because they're more likely to be active in different countries in a certain mega region. They're more likely to have the capacity to actually use these procedural provisions that are in the agreement. That's one aspect. Another aspect is to look at the agreement in detail and to tease out what a provision actually achieves. And while very cumbersome and sometimes boring, this is essential to get it right. If trade analysis and trade law analysis operates on a level of generality, where the question is whether an agreement has a digital trade chapter or not, you won't get to the questions that really matter. And my colleagues who wrote the remote control piece, they did that for a variety of procedural requirements. And what they found was that the requirements, say for the pharmaceutical industry, giving them procedural rights, enabling them to use data in a certain way to get them medicines approved, were very precise, very clear, very sharply worded, so harder to avoid for the regulatory states that are then subject to these provisions. Whereas procedural requirements that related to environmental obligations tended to be much vaguer, much broader, with more ambiguity of what they were actually trying to achieve, which makes it harder then for activists and NGOs that want to push international environmental interests to use these provisions in the same way. So asking this question, I think is absolutely imperative. And the key insight here is also reflected in Katerina Pistor's book of law as the Code of Capital, where she's talking about the ways in which lawyers in law firms can shape law to advance the interests of global capital. And the similar dynamic is certainly prevalent in international economic law, and pointing that out is, I think, important to reshape and recalibrate international economic law to address the issues that we might want to address instead.
Thank you very much, Professor Thomas. Here's your second question. Those who advocate for greater democracy in international legal affairs, do they have anything to cheer about non-state driven, for example, ICAAPMM regulations than the formal treaties?
That's an excellent question. Thanks a lot. It's a very complicated one. I'll maybe start with ICANN. So ICANN is the Internet Corporation for Assigned Names and Numbers that is in charge of the global domain name system. And it's dear to my heart because it's the entity that I worked on initially when I joined NYU. And it's the one that convinced me of the value in adopting the SLAWN global governance framework that has been known as global administrative law. Because if you look at ICANN through the lens or formal law, it's a non-for-profit corporation under California law. So the relevant law is California law. But if you recognize the function that ICANN fulfills in the global economy today, which is to regulate the domain name system without which the internet could not function, one sees it as a global regulatory body, and then the question becomes whether there is some kind of global regulatory law, global administrative law, that checks the power that this regulation, that this entity has. And ICANN has been at pains of creating procedural requirements and other forms of accountability within its multi-stakeholder structure to satisfy the demands of those who felt that this kind of power should not be in the hands of a private corporation that operates under the jurisdiction of the United States. In the very beginning, after ICANN was founded in 1998, there was an attempt in the early 2000s to turn ICANN into a quasi-democratic entity by having elections, global elections, to elect the board members of ICANN's board of directors. But the problem was that the participation at that global election to democratize global internet governance was lacking and heavily skewed towards white male Americans. So this was in some ways a cautionary tale about the extent to which these new configurations and new forms of global governance can satisfy basic commitments of democratic governance. And they raise huge questions about democratic legitimacy. The same is true for other types of technical standard setting organizations. But the democracy question is, of course, also a question to be raised about the World Trade Organization or about international economic law more generally. And that, I think, is my second point here, which is that one can see the standard paradigm operating with a certain idea of democracy as well, where if you think that trade law is about national economies being congruent with nation states who are represented by governments that are ideally democratically elected, and then they negotiate agreements among each other that are being ratified by national parliaments that mainly deal with issues of trade. So border issues and cross-border issues that ought to be addressed in a trade agreement. We can tell a story that we say that this is fine. The government is democratically elected and the agreement is ultimately being ratified. The reality now is that these agreements are no longer just about trade. They're about global economic governance, and they touch all areas of life. If you want to have a data protection law, you now need to pay attention to the data governance provisions in international trade law. If you want to have health law reform, you need to pay attention to the provisions in international economic law. And this expansion of coverage in issue areas is not reflected in the ways in which these agreements are being negotiated, because they're largely being negotiated in secret. And it's also not reflected in the ways in which the domestic constituencies are able to exercise influence on the decision makers in parliaments, because in many cases, the parliaments don't really have a choice in meaningfully constraining the negotiators in the types of provisions that are being negotiated. I'm personally very interested in coming up with ways in which we might imagine new types of transnational alliances, transnational configurations that might be able to create a kind of collective governance that is more democratic in the sense of more public regarding. But the current way in which these provisions that are just of a general nature in global economic governance are being negotiated in instruments of international economic law is fundamentally in tension with democracy.
Thank you very much, Professor. Our third question. Could you please explain who are the more enthusiastic proponents of the Foreign Office model, economically backward states or advanced economies, and why are they so?
Thanks a lot. That's a tricky question because it depends on who you're focused on. So for me, the Foreign Office model and the global governance model are mainly paradigms that help me in my research and that I recognize among other scholars. So it's if you are looking at scholars, you see many who are operating within the standard paradigm, sometimes they are self-aware of that, and sometimes they might not even be self-aware of it. And there's also nothing wrong with that. There are a lot of interesting legal questions one can study and tackle under the standard paradigm, and I don't want to disparage that at all. And then there are scholars who have shifted or have started to shift towards this, what we perceive as a new paradigm. And I'm particularly excited about the potential to use the new paradigm and to make visible these various interactions between international economic law and the various stakeholders that are involved in global economic governance, to make visible distributive effects, to make visible issues of justice, to imagine different regulatory solutions for issues like climate change or global data flows. So, and I encourage all scholars who are interested in that to join me in that effort. So that's on the scholar side. But I think the question was more geared towards countries. And there it's interesting. There's a certain perception, or there was a certain perception initially, that when global administrative law was created at NYU by Benedict Kingsbury, Nico Krish, and Richard Stewart, that in some ways this was not a global administrative law, but a US administrative law scaled, and scaled to justify the regulatory activity of global regulatory bodies that were often US dominated, to the expense of other entities and states that didn't have or still don't have influence in these kinds of global regulatory bodies. And that's a critique, kind of third world approaches to international law type critique of global administrative law. And I think there's some truth to that. So this endorsement of multi-stakeholderism, the creation of private governance entities or hybrid entities, the ideas for these kinds of regulatory solutions for problems of globalization often came from the global north. And there's also a perception that that states that are not in the global north often have a more traditional understanding of or operate in the international arena by giving more focus to traditional intergovernmental organizations. And that's definitely the story that is at least being told in internet governance, that as a push against ICANN, the better solution that developing countries in particular have been advocating for would have been some entity that operates under the roof of the United Nations. But I'm actually doubtful about that generalization. I think it might reflect more of a kind of skewed prism that doesn't consider enough the non-state entities that provide regulatory functions in the global south. And I'm thinking in that regard also about my friend and colleague Edefia Jomo, who has written her PhD or JSD thesis at NYU about remedial governance structures when states are not able to fulfill their functions to the extent they should, or to the extent citizens would expect it, whether regional governance institutions could remedy that, and how to do that if the traditional way to create regional integration, the European way, doesn't work because it depends on a functioning nation state. So how else can one create remedial governance institutions without the state, or by relying more on other non-state actors? So I don't think it's right to say that one model is more favorable looked at in the north or in the south.
Thank you very much, Professor. The next question, it comes from Antara Tasnim. She questioned, how, in your opinion, can the paradigm shift you suggest in international economic law can more successfully integrate non-trade factors such as human rights, environment, etc.?
Yeah, that's a very good question. As the person who asked the question probably knows, that there is a long debate about non-trade issues in trade law and whether it makes sense to expand trade law in this way, and how to align or create some form of harmony between the international law regarding human rights or the environment and the international law regarding trade, with many trade activists and environmental activists being very skeptical about the prospect, fearing cooptation, and often advocating for a separation of these spheres. My personal view is that it's almost impossible to not talk about human rights or the environment in a trade context, because under conditions of globalization, there are so many ways in which trade law directly or indirectly impacts the lives and livelihoods of many around this globe, including their health, including the environment in which they live, and including their life choices and possibilities that economic and social rights in particular are supposed to protect. So the answer I would give is that we ought to think differently about international economic law, and the paradigm shift might help here. I've been laboring on a draft paper for years now that is trying to articulate that idea in more detail, where the idea is, if it's the case currently that international economic law mainly benefits globally operating corporations, maybe we can imagine international economic law that regulates globally operating corporations. And the basic idea there is to condition the benefits, especially the excludable benefits that they receive from international economic law, on behavior that we deem desirable for economic, social, or cultural reasons. So that could include certain minimum tax payments, that could include certain commitments against the use of child labor, that could include certain commitments towards privacy as a condition of cross-border data flows, instead of granting this right to transfer data from one country to the other without conditions being placed on the corporate entity. So that's my personal idea here, to leverage international economic law into a tool to regulate globally operating corporations, which sounds counterintuitive, but I think at least conceptually, there's no reason why we couldn't do this. It's a different question whether one could mobilize the necessary political will to actually achieve that in practice.
Thank you very much, Professor. Our next question is from Anna Solis. She is a professor of LLM. She asked, CPTPP SPS chapter eludes biotechnology from its chapter and includes it rather in the market access chapter. It also omits the precautionary principle and creates a differentiation between risk assessment and risk management that undermines what until now many scholars thought overcome on what constitutes science for SPS purpose. Do you think CPTPP SPS chapter constitutes a shift of paradigm or simply an attempt to reform WTO SPS agreement due to the impasse of Doha?
Okay, thanks a lot for this excellent question, but I almost assume that the person who asked the question knows more about the CPTPP SPS chapter than I do. What I can say is, in response, that it's striking how the content and structure of these mega regulatory trade agreements is often in tension with regulatory disciplines and regulatory concepts that are well known and well established in domestic law. It's a mistake, in my view, to look at these agreements and to get blinded by the chapter structure. It's quite often the case, as the person who asked the question pointed out, that we find provisions in chapters that are actually speaking to other issues. And the e-commerce chapter is probably the best example for that. There are provisions in there that relate to traditional trade disciplines. There are provisions in there that are arguably really about intellectual property law, so they should be in the intellectual property chapter. There are provisions in there that are about cybersecurity issues, where the trade nexus is often really tenuous. There are also all these provisions on spam, for example, where you can tell a story how fighting spam is important because otherwise people don't use email. And if they don't use email, maybe there's less electronic commerce or that's a burden on electronic commerce. But one needs to jump through all these hoops to create the connection to trade. Whereas if one understands it as a pure exercise in global economic governance, it's much easier to actually analyze the provisions. And I would be happy to follow up on the precautionary principle and the risk management categories that are being established there. Our hunch when writing about TPP was that a lot would depend on the practice on the ground. So how would domestic regulators react? And would the institutions that TPP creates, including the TPP committee, play a role in harmonizing different understandings of what the provisions in TPP entail. I should also point out that TPP is trying to build on the WTO and trying to build on a whole range of other international agreements. So that's another feature of these mega regulatory agreements. They often actually don't contribute to the fragmentation of international law, but they harmonize international law to some extent by requiring their parties to accede to certain international agreements they might not yet be party to, or by pointing out that TPP should be operated in a way that is consistent with these other international agreements. But I wouldn't be surprised if that's not the case for the SBS chapter, or that's at least, I think, something that one could debate and should definitely look at.
Thank you very much, Professor. Due to time constraint, we're not being able to take more questions, but we can just take one more question if that's all right with you, Professor. The last question. Would it be fair to say that the RCEP agreement's rules on digital trade is significantly shaped by China?
Thanks for the question, which is on my favorite topic at the moment. I wouldn't put it that way. And if you want to read my take on RCEP's data governance provisions, I have a blog post in James Gatti's Ergonomics Law blog that was carefully edited by Professor Islam. The RCEP is arguably better understood as an extension of ASEAN, the Southeast Asian Regional Economic Integration Organization, which created a mega regional agreement based on the free trade agreements that ASEAN already had with other parties that are themselves not members to ASEAN. And several of those are also members of TPP. So if I look at RCEP and hold it next to TPP, I see a lot of parallels, in particular in the digital trade chapter, in terms of structure and in terms of issue coverage. At the same time, there's a clear influence by countries like China that are not interested in the kind of dynamic that I explained in my second case study. China does not want to change its data governance regime in response to RCEP. China wants an RCEP that allows it to keep its data governance regime. And they achieved that by modifying the provision that is the equivalent to Article 1411 TPP in a way that allows much broader justifications. So under TPP, countries can also restrict data flows, but their restrictions of data flows need to be necessary. And whether they are necessary is to be decided by a panel of arbitrators if it comes to state-to-state dispute settlement. In RCEP, the digital trade chapter is not part of state-to-state dispute settlement. And the provision on cross-border data flows and data localization allow parties to restrict cross-border data flows and to require data localization when they, not someone else, considers it necessary. And there's an additional carve-out for security-based measures, which is the framing that China adopts. And I've just a new paper out with Matthew Erie on China's influence in global data governance that we call the Beijing effect, that also talks about this issue, how China seeks to preserve its approach to data governance in its commitments on international economic law, whereas the US has been trying to scale its approach to what I've called the Silicon Valley consensus in agreements like TPP and the USMCA and the US-Japan Digital Trade Agreement.
Thank you so much, Professor Thomas. Thank you very, very much for actually giving the time for this wonderful talk of yours and for entertaining the questions. You'd like to know that we actually have a very good number of participants, and this particular talk will be available in our YouTube channel. Professor Thomas, before you leave, would you like to say anything to the participants, to the students, or the faculty members of North-South University, or everybody present here?
No, thanks a lot to you and Professor Islam for inviting me. It's been a true honor and pleasure to engage in this forum. I think it's one of the advantages of the Zoom age that we are able to have these kinds of events, but I would love to meet at least some of you one day in person, whether in Bangladesh or somewhere else in the world once this terrible pandemic is over. And I hope, especially for the students, that you got out that you got something out of my presentation. And I'm always happy to hear feedback and to give pointers to interesting research avenues. And I wish you all the best for your careers in the law and for your further studies. Thanks a lot.
Thank you very much, Professor. Thank you very much, and good night, everybody.